Filing bankruptcy during divorce in New Jersey. Going through a divorce is hard, and adding overwhelming debt and the prospect of bankruptcy makes it even more challenging. In New Jersey, the financial and marital issues are so intertwined that timing and planning play a crucial role in both processes. Understanding how bankruptcy law intersects with family law can help protect your rights during this difficult period, and working with a seasoned bankruptcy lawyer can provide the clarity you need. When you file for bankruptcy, an automatic stay immediately halts most creditor actions. This stay freezes equitable distribution. The debtor's assets, including marital property, become part of the bankruptcy estate under the exclusive authority of the bankruptcy trustee. Family court judges cannot divide assets or debts while the stay is in effect. However, the stay does not stop proceedings related to alimony or child support, called domestic support obligations, child custody or visitation, domestic violence cases, or the dissolution of the marriage itself. Because alimony and support depend on a complete financial picture, many judges pause the whole divorce case until the bankruptcy is resolved or the stay is formally lifted. To restart equitable distribution, a party must file a motion in bankruptcy court to lift the stay. Deciding when to file is a strategic decision. A joint bankruptcy before the divorce is final can be cheaper and more efficient because couples pay one set of court and attorney's fees. Joint filers may double many bankruptcy exemptions, allowing them to protect more property than either spouse could alone. Discharging unsecured joint debts, such as credit cards, before the divorce may lead to a cleaner financial slate. But this path requires both spouses to cooperate by providing complete financial disclosures and attending hearings, which may be unrealistic during a high-conflict breakup. Couples who file jointly must also pass the Chapter 7 means test. Combined incomes can push them into Chapter 13, whereas separate filings after divorce might qualify them for Chapter 7. Additionally, if the couple owns valuable non-exempt assets like a vacation home, the trustee can liquidate them to repay creditors. Filing after the divorce gives each ex-spouse control over their own bankruptcy. With lower individual incomes, people often qualify for Chapter 7 more easily, and the divorce decree clarifies which assets and debts belong to each person. This independence has drawbacks. Divorce decrees cannot bind creditors, so if one ex-spouse discharges a joint debt, the creditor may pursue the other spouse for the entire balance. Separate filings also mean higher costs, and each party loses the benefit of doubled exemptions. Choosing the right type of bankruptcy also matters. Chapter 7 is liquidation. A trustee sells non-exempt assets to pay creditors, and most unsecured debts like credit cards and medical bills are discharged. The process is quick, usually 3 to 6 months, and is best suited for individuals whose income is below the state median. In divorce, Chapter 7 does not discharge debts arising from property settlements or equitable distribution. Chapter 13 is a reorganization that allows the debtor to keep all assets and make payments to creditors over 3 to 5 years. It's often used to stop foreclosures or when the filer's income is too high for Chapter 7. A key divorce implication of Chapter 13 is the super discharge that can eliminate certain property settlement obligations that are non-dischargeable in Chapter 7. A spouse ordered to pay a large settlement could later seek to discharge that debt in Chapter 13, so the receiving spouse should work with a knowledgeable attorney to ensure that obligations are characterized as alimony or support, types of debts that cannot be discharged in either chapter. Potential pitfalls extend beyond timing and chapter choice. Informal property transfers between spouses before bankruptcy, such as transferring a car or cash to settle debts, can be reversed by a bankruptcy trustee if deemed fraudulent. A well-drafted indemnification clause in the divorce settlement can protect against phantom debt by requiring a spouse who fails to pay a joint debt to reimburse the other for any amounts collected, including legal fees. Courts may treat these clauses as support obligations, making them non-dischargeable in bankruptcy. Tax consequences also matter. Dividing retirement accounts without a qualified domestic relations order or selling a marital home can lead to penalties or capital gains taxes. Consulting professionals who understand both the legal and tax implications is vital. Filing for bankruptcy during a divorce is not just paperwork, it requires careful coordination and informed decisions. Whether you aim to discharge debt, protect assets, or secure a fair divorce settlement, the choices you make now will have lasting legal and financial consequences. The seasoned lawyers at Straffi and Straffi attorneys at law can guide you through each step. Their law firm is located at 670 Commons Way, Toms River, New Jersey 08755, and you can reach them at 732-341-3800. This law firm can help you navigate the intersection of family and bankruptcy law, and a trusted attorney will work with you to chart a path toward financial stability.